I'm going to make a couple of announcements before I get into my presentation. First one is, we noted Jenna was here this morning from the BLM. Would all of you that are here from the BLM raise your hands and just let us know who's here listening to what's going on? Please share with us. Thank you for being here. Forest Service, Terry, Angie, Angeli? Okay, and the Forest Service, you have other folks here, please raise your hands. We appreciate you being here. We want this to open a dialogue, Terry, as you and I have talked, so that we can all be on the same page and have more continuity and remove this uncertainty. So thank you for being here and being part of this. Another announcement, this was left at lunch. It's a very nice sandstone it looks like, but somebody can correct me when they claim it. Is it sandstone or is it turquoise? It's sandstone. I guessed right the first time. You're welcome. And the other thing I'd like to do is just again acknowledge the sponsors and contributors. Very nice lunch. It was one way we could get done in about an hour, and we were able to do that and welcome you back. Thank you. And now I'm going to do the advertisement. Farm Bureau is a membership organization, and I think you all probably know that. So here is the advertisement. Being in a membership organization, we operate based on the people we represent and their contributions from a membership standpoint. I take grazing and water issues very personally because I come from a ranching background. I told some of my friends here, I admitted here not too long ago, that I've been grazing on public land since I was 8 years old. I never read a grazing permit or an annual operating instruction till this last summer. But I learned a lot, and I would recommend every one of you read your allotment, your annual, your plan, whether it's forest or BLM, and know what your grazing permit says. Your annual operating instruction cannot change your grazing permit, but at the same time, it does define what's going to happen in that grazing season. So I learned a lot by reading it for the first time. Read your grazing documents. All right, now let's talk water. AJ, you up there? You backing me up on this? Okay, I'm going to talk a little bit about states' rights and private property. Where do I point? You? Oh, that's not the right one. That one is. All right, again, the conference, that's who I am, and any of you that have a question, please get in touch with me or Utah Farm Bureau. We're out there to be your advocate. We work closely with the Cattlemen's Association and the wool growers and other organizations, but if you've got questions, member or not member, please contact us. Thomas Jefferson, third president of the United States, said, "When the people fear the government, there is tyranny. When the government fears the people, there is liberty." I worry about where we are 250 years after that comment. I think there's far too much fear of the government, and that includes the IRS and certainly others. So I want to put that in play to begin my comments. I've been honored to represent you in the grazing interests in the state of Utah and in the western United States 4 times before the United States Congress. The 3 times before the Natural Resources Subcommittee on Water and Power talking about water rights and grazing issues, and 1 time before the Committee on Oversight Subcommittee on Interior talking about threats to grazing on due to federal regulatory overreach. Let's talk about the water clause and also about what I call de facto federal water rights. Congress has acted numerous times in in telling the states they are the sovereigns as it relates to water. They've told the federal government only when Congress grants you a reserved water right do you have a right to that water. That's an important fact as I go forward. Reservation of water rights by Congress. In the Act of July 26, 1866, that's what we refer to as the Mining Act. That act established priority of possession. The Desert Land Act of 1877 established that the states appropriate the water. Taylor Grazing Act continued and said these rights are established based on possession. The McCarran Amendment, this is really an important one to keep in mind. The McCarran Amendment determines that the states are supreme. That act actually said it waives the sovereign immunity of the United States. That's important. Even FLIPMA honors existing rights. All actions by the Secretary concerned under this act shall be subject to valid existing rights. The U.S. Supreme Court, and this is a recent ruling, just 2013, just two sessions ago, said that the power to control public uses of water is an essential attribute of state authority. I'm going to read that again because that's the United States Supreme Court. The power to control public uses of water is an essential attribute of state authority. That's what Congress granted us. The Organic Act, which is what the Forest Service basically operates under, has limitations, and in United States versus New Mexico, 1978, it defined two basic ideals. The first one is to secure favorable water flows for private and public uses under state law. It doesn't say to favorable flows for those uses, it says under state law. Gifford Pinchot, the first chief of the Forest Service in 1907, said the creation of the National Forest has no effect whatever on the laws which govern the appropriation of water. This matter is governed entirely by state and territorial law. All right, now I'm going to get into one of the areas that I believe is a major overreach, and that's the water clause by the U.S. Forest Service. The Forest Service in rulemaking in 2004 said two things. One, it said that to use and divert water based on your permit to use the federal lands, you had to hold that water joint with the United States. They called it a joint water right. That's troubling enough, but the second piece of this is even more troubling, and that is the bottom line. It says, in the event of revocation of this permit, the United States shall succeed to sole ownership of such joint water right. I don't know if that gets your attention like it does mine, but when we lose access through RS 2477 closures, we lose grazing rights, and I'm going to go through those numbers here in a little bit. All of those things play into, in the event of revocation of your permit, federal government says that that water now becomes their property. Second concern I have, and I'll go into this in more detail, United States Fifth Amendment to the Constitution guarantees you due process and guarantees you just compensation, and I don't see that anywhere in it. All right, here's the nature of water flowing from the forest system lands. Nationally, across the U.S., 14% of the water. In the western U.S., public land states, 50% of the water. Let's look at Utah now. 75% of the water flows from the forest system lands. If we don't have control over it as sovereigns, as state and private property rights, we become further it challenges our sovereign rights in determining our future if we don't have the control of that much of our water going forward. Harv Forsgren, the past Intermountain Region forester, said it is the Forest Service policy to claim water rights for water used by permittees. The Forest Service believes water resources used to water permitted livestock are integral to the land. Therefore, the United States should hold the water rights for current and future permitted grazing. That was testimony before the Congress in 2012. In fact, that is part of the Forest Service manual. You'll note claim possessory interest in water rights in the name of the United States, claim water rights for water used by permittees, contractors, and other authorized users of forest system lands. It's right in the manual. Here's what I was telling you a few minutes ago. We have citizens' protections in this land. It's called the Fifth Amendment to the United States Constitution, and we have a guarantee that we have due process and we have just compensation for anything that government takes for the public. And that's what concerns me about the water clause, and that will revert to sole possession of the United States. There's no due process in that. They just canceled your grazing permit and your water went by the wayside. That's a property right under Utah state law. In fact, the Utah Constitution even guarantees greater to protect you from a taking. It actually says not just the physical taking of your property, it also says if they diminish your value, if they do something that diminishes the value you have in that property right, as an example, you can't get access to it under Utah's Constitution, that's a diminishment of your value in that resource. The U.S. Supreme Court has set some limitations on government agencies, and I think the seminal case is the one I'm going to show you right now. This is Swanks, Solid Waste Agency of Northern Cook County against the Army Corps of Engineers. I could go through and read all of this. This is and if I were you and you had an interest in where the limitations are for federal agencies, this is well worth your read. But in the red at the bottom, it basically says, don't upset the federal-state balance, and this is pertaining specifically to water. Don't upset the federal-state balance, and don't go where Congress has not authorized you to go. Okay, some of the agency actions I want to just visit that they are challenging the federal-state balance. Again, quoting from regional guidance, the United States may claim water rights for livestock, and they're basically saying that they claim that until a court is willing to accept these claims. So they're teeing this up for the federal government to figure out a way that these claims become the property of the United States. And I'm going to talk about state law that's protecting you here in a few minutes. The interesting thing is, and many of you are facing this right now, as you're moving forward with your grazing and doing the things that you need to maintain and to develop the waters that you have on your grazing allotment, there's a lot of times when you have challenges to your ability to maintain or to develop those water rights, to pipe it, to do whatever you need to do to better manage your livestock water right. And it's interesting that the Forest Service came out with this ruling. The Intermountain region will not invest in livestock water improvements, nor will the agency authorize water improvements to be constructed or reconstructed with private funds where the water right is held solely by the livestock owner. That's, as I've learned in recent weeks, that is also being followed by the BLM now. So they're basically holding you somewhat hostage to either giving up your water right or holding it jointly or something to that effect before you are giving authority or authorization to maintain or improve or develop your water right. And I'll show you in a few minutes that that's in violation not only of state law, but also flies in the face of the Federal Land Policy Management Act. Adverse actions, this is one that is really frustrating, these de facto water rights. Road closures, how much of that's happening? Any of you had that happen in your neighborhood? where you can't get to your to the land that you had been historically able to. That's happening more and more. We've got 16,000 diligence claims that have been filed on livestock water rights scattered across the Utah landscape, waiting for the state engineer to determine, does the federal government have claim to that? The federal government claims that because those waters were put to beneficial use by you as ranchers when you graze cattle and sheep prior to statehood, because they were the owner of the land, that translates to today that they have the ownership right in that. I'll show you a Supreme Court ruling from Idaho that says otherwise. And then, of course, cuts and suspended grazing AUMs where you're not able to get your water and beneficially use it. This is the diligence, 16,000. Harv Forsgren said these diligence claims are made on behalf of the United States, which was the owner of the land grazed prior to statehood. This is comments he made before the House Subcommittee, or the House Natural Resources Committee in 2012. I'm going to go through some numbers here, and I've been working on these numbers now in excess of 5 years, and I'm very confident in these numbers. These come from agency records, and they come from Utah State University archives. So I'm very confident in these numbers that I'm going to present to you. Forest Service grazing AUMs, going back to 1940, they allocated 2.7 million AUMs in Utah for grazing interest, for ranchers to use on as part of their operation. Private land, as I said earlier, private water, and public land to make an economically viable, and that's weird, an economically viable operation that is sustainable. So in 2012, we're down to 840,000. Of that 840,000, 226 are in suspended use, leaving 614,000 AUMs that are actively being grazed today. That's 77% since 1940. That's dramatic if you're a ranching interest to try and weather that. I will tell you, between the BLM and the forest, and I'll go to that one next, the BLM started at about 2.8 million AUMs. 2012, the number was about 1.2 million with 312,000 in non-use, leaving about 880,000 AUMs. They've reduced by 68% the number of AUMs for livestock grazing. Those are striking numbers on their own, but I will tell you even a worse striking number, and that is in 1950, there were about 3,600 ranches in the state of Utah that were grazing on BLM and forest system lands as part of their annual grazing. As of 2012, that's under 1,500. We've lost 60% of the ranching families that ranched in 1950. Now, I will agree, and Terry and I have had conversations on this, that there's a lot of things that have played into that, livestock economics, urbanization, and all of that, but uncertainty of where you're going to be able to graze your livestock is a big issue, folks. Here's the case that I was going to share with you regarding the state having the opportunity to define beneficial use. Joyce Livestock Company, 2007, the Idaho Supreme Court defined beneficial use, and in that it said because the United States did not actually apply the water to beneficial use, and then it goes on in their ruling to say they cannot hold a livestock water right. That was after both the BLM and the Forest Service sued the Joyce family, and after a decade of litigation in Idaho, that they finally got a decision in 2007 out of the Idaho Supreme Court that said, you don't have the mechanism to beneficially use that water, therefore you don't have the right to hold a livestock water right. I will tell you that Utah law, water law, is very similar to Idaho. In 2008, following the leadership that came out of Idaho, Mike Noel, a few of you guys in this room probably know Representative Noel. He called me after the Joyce decision. He said, Randy, we need to do something in Utah, similar to what they did in Idaho. So I worked with Mike Noel and we drafted the Utah Livestock Water Rights Act in 2008. We made a couple of mistakes. We defined the beneficial user as the livestock watering right as the owner of the livestock grazing permit. We found that very quickly the federal agency said we're the owner of that livestock grazing permit, and that became kind of a bone of contention. And so we actually made a change that I'll show you in 2009. The other thing that happened there is it was defined that water right is appurtenant to the grazing allotment. You'll hear a lot of times the agencies will argue we have to keep that water on the land so we can protect that for future generations. Well, you know what? Utah and Idaho both make that appurtenant to the livestock grazing allotment. It can't be moved. That is by statute. Problem was that with that claim of them being the owner of the permit, we changed that so that the agency could actually hold jointly a certificate of joint ownership, which created its own set of problems, and I'll note that in a minute. In 2014, following the leadership of the U.S. Congress and the Water Rights Protection Act, Utah again addressed this livestock water right issue. And this became a big sounding board for the state of Utah that we have sovereign rights that were granted us by Congress, and this takes it away. And so the state of Utah changed the law, and the first thing it did was it deleted certificate of joint ownership. I think it's important to know that when they did that, that certificate conveyed no interest in water. That's an absolute. We've talked to the Attorney General's office. There was no conveyance of a water right. It was just a certificate to hold with the rancher. So we feel strongly that that deletion is not a legal obstacle. Second thing we did was we defined the beneficial user, meaning the person who has the right to use the grazing permit. Next. The beneficial user does not mean a public land agency that issues the permit. Then we said, and this is important, and keep this in mind, the state of Utah said this provides a right of access and to improve an allotment as necessary for the beneficial user to beneficially use, develop, and maintain the beneficial user's water right. So this says, under state law, the state recognizes your need to maintain your water right, to develop your water right, and for the state to control that water right. That's important under Utah state law. And then the final thing, all of those water rights that are out there scattered across the landscape that no longer have grazing, that 74% that are lost AUMs, the state provided that those water rights will be held in trust by the state until such water may be appropriated to a livestock watering interest, as consistent with state law. All right, now I told you I'd tell you what FLPMA has to do with this. Federal Land Policy Management Act, Title VII, Effect on Existing Rights, Section 701, nothing in this act shall be construed as limiting or restricting the power and authority of the United States. You know, okay, we'll take that. But the number 2 under that, that's related to water, says as expanding or diminishing a federal or a state jurisdiction, responsibility, interest, or rights in water resources, development, or control. That's in federal law right now. That is the state's right to develop and control that water. And if an agency is not allowing you to maintain your water right, it appears to me it's all in violation of both the state's Livestock Water Rights Act as well as FLPMA. Congress has been really concerned about this. Somebody tell me what time it is. I'm 1:41. How much time I got? Not much? 5-10 more minutes? Okay. Congress has been very concerned about this, so I'm going to go through this quickly, and if you've got questions on it, you can call on me, because I've been involved in drafting this legislation. The water clause was challenged by the ski industry when they made the ski industry sign a joint interest in Colorado. And the federal judge over there said it violated their own regulations and did not evaluate economic impacts. The ski industry said it was a water grab. Western ranchers have been arguing in Congress that what they're doing with the water clause violates Congress, violates state and federal court decisions, and is in violation of state law. So guess what? Western ranchers, and I was up there very involved in this, and the ski industry worked with Scott Tipton from Colorado, and we drafted the Water Rights Protection Act. That prohibits imposing the water clause or joint ownership as a condition of your permitted activity. It passed the House last year, 238 to 174. Harry Reid was in control of the Senate. Can anybody guess what happened to it? You got it. All right, 2014 Congress. It's there again. The House has passed it, but we added that it stops the implementation of the Federal Groundwater Resources Management Directive. That was an overlay of federal regulations over the state engineer and his role as the chief engineer of water in the state and in the states. It also says that you will honor state water law. This bill is already in the Senate, and I'm working closely with Senator Lee's office. I'll be in his office in D.C. next week with Chris and seeing where that's going. It's on its way to markup. All right, this is the act. It's in markup. This is a quote that I like to have you think about as I come to the end of my presentation. Chief Justice John Roberts, in an analysis of the structure of government as envisioned by the framers, said, "The states are separate and independent sovereigns. Sometimes they have to act like it." Now, in your packet, there's a 5-page how-to that my good friend Ramona Hage Morrison provided for us to help you understand your chain of title on your water rights and how to establish that. Please take a look at that, because that's how you can protect your vested water rights. And I like this picture. Whose family is that? I think they might be in the room. You're here? Thanks. I love that picture. That to me is what America's about. Thank you for it. I appreciate it. I think I got a couple of minutes for some questions. I really kind of pushed the envelope in getting through that, and I may have left some things unanswered. So if you've got any questions, let's take 2 or 3 or 5 minutes right now. No?
Yeah, no, Randy, I do up here. Dustin. So, acting like a sovereign state, how do you do that when we were told earlier that we just don't have grazing rights and whenever they go? How do we act like a sovereign state?
Dustin, one of the things that I think is really important to recognize in this equation is Congress has acted at least 5 times and possibly more to identify the waters as belonging to sovereign to the states. So there's no question about that. In fact, Congress has only acted to reserve a water right for the federal agencies, and they can't go, basically they can't go beyond that. They want to redefine it, yes, but the state of Utah has every right and responsibility. The water in the state of Utah belongs to who? Belongs to the citizens. You have a private property interest in that water right because of the way we beneficially use water, first in time, first in right. And so one of the things that I think is important is to exercise that right as the owner of that livestock water right, to exercise it, to challenge the ownership and become the rightful owner of those state sovereign rights. Other questions?
So, Randy, there's several projects, water improvement projects on rangelands right now that actually have funding in place, but one of the big hurdles that are getting over is that the very thing that you talked about is the permittees having to sign over their water rights or certificate. So is the certificate thing going through, or is it still a water right that these guys are going to have to sign over?
The certificate has been deleted. It has no validity under Utah state law because it didn't convey an interest in the water. That was the Attorney General's opinion, and so we didn't want first to muddy the legal water, so to speak, and second, when you read that second part of the water clause that says if for some reason your right to your permitted activity is canceled, that water reverts to the sole possession of the United States. That's troubling to the lawmakers on Capitol Hill, especially in the current setting where the state of Utah believes that the best interest of the citizens of the state is to transfer the federal land to state ownership and control. I will tell you right up front, right now, no bones about it, Farm Bureau supports the transfer of the federal land to state and local control. Another question?
My question is, what good is a water right if, in our case, the BLM cut our winter allotment in half and took away from us 170,000 acres? And in doing that, they denied us access to 11 freshwater springs that we had water rights to. So what good is that water right if I can't use it?
You have just hit on the crux of the issue, and I will say out here openly that this is probably an issue that will have to be resolved in court. That is the sovereign rights of the state of Utah. Those are your private property rights. I know that Tony Rampton this morning went through a litany of case law that says that the federal government has every right to do what they're doing, but you look at the conflicting federal laws. That includes FLPMA that says that the state has every right to determine the use and to control and maintain their water. So that's probably an issue, and I'll tee this up for Kathleen, that the state of Utah ought to take a look at standing up on behalf of the citizens of the state and the waters that belong to you that are scattered across the landscape. I think that's going to take a legal ruling. Matt, one more question, then we'll move on. Anybody got one more? Back there, Matt. Brian and Ron, why don't you guys come on up?
I've got now in these monuments and parks, there's water in those parks. Okay, they've taken the grazing, especially in the parks. What happens to the water?
That is one of those, Senator Hatch, and I think the bill is in your packet on the monument and protecting grazing rights, and I think it does some on Ron, it does some as well on protecting the water rights within the monument. That's one of those that is moving forward that will need to be answered, Dick. I don't know the answer to that. I do know one of the answers to that, and the reality is unless Congress reserves a water right to that particular activity, then the federal government does not have a claim on that water right. That's the way I understand it, Dick, and I think that's part of what Orrin Hatch and Mike Lee, the two senators, have done in protecting the historic rights within the monument. I don't think I'm misspeaking on that, Ron, Ryan. All right, thank you.